Associate Director of the Bob Williams Center, and so pleased to see all of you here tonight for this program. And tonight we're so grateful to have Jon Mills, Dean Emeritus of the Levin College of Law, Director of the Center for Governmental Responsibility, and former Speaker of the Florida House of Representatives, here to interview and talk with Dr. Howard Simon, who is Executive Director of the American Civil Liberties Union of Florida, and the longest-serving ACLU director in the country since 1974. Wow is right. And they're going to be discussing the big challenges ahead for the ACLU. I'll remind you to turn off your cell phones, and at the end, of course, we'll have a time for Q&A, and please come to the microphone because we are streaming and recording the event, so we need to be able to capture you. So I will turn the program over to Jon Mills to begin. Thank you.
Thank you, Gail, and thank you all for being here. Thanks to the Graham Center for its continual great organization of interesting and important events. It's a pleasure to have a chance to interview or talk with Howard Simon. I've been talking with Howard Simon for years now on various different issues, and he's a dedicated advocate for civil liberties and a person who's unafraid of conflict, the truth, and the Constitution. So we're going to talk about several issues, elections generally, free speech, and maybe the Constitutional Revision Commission in its context. We'll start with elections, and when Howard and I were just upstairs, we were saying there used to be a premise that government and most of us liked to maximize the number of people who vote. That is, voting is a good thing. Participation is a good thing. The ACLU has been in a position where it had to challenge from time to time the actual implementation of laws which would restrict voting. Now, of course, we don't want there to be fraud in voting, and I was thinking of this walking downstairs. There's the Huey Long story. Huey Long, you may remember, was the governor of Louisiana. There were occasional charges that Huey might have been involved in corruption. But Huey, on his deathbed, in a conversation with his family, said, well, Huey, how do you feel? He said, well, I do feel unfortunate that I am dying, but the good thing is I'm going to be buried in southern Louisiana, and I'll still be able to vote. So, Howard, we were talking about issues that you've been compelled to challenge in elections, and we're talking about several issues in elections, most of which are talking about getting more people to vote or have a more just structure. So, what are those issues that you think?
Well, I hadn't heard that story from Huey Long. The version of it that I heard was about the little old lady that was very active in the Democratic Party in Indiana and requested that she be buried in Chicago so she can continue to be active in party politics.
Right.
But anyway, it's all the same story. But John, it occurred to me that maybe, I don't know whether this is a new phenomenon or whether this is the dirty secret of American politics, that where it was always the public image about, we got to get turnout. You got to get my people out to vote. You got to get my supporters out to vote. But maybe the dirty little secret of American politics was that there was always an effort at the same time to do what you can to dissuade the others from coming out to vote and build as many barriers as you can. I don't know whether or not that has always been the case and it's now just public, but we are been up to our eyeballs in those kinds of issues, especially since 2011. 2011, things changed dramatically. There was an increase in participation and turnout in elections from 2008 to 2010. Not surprisingly, there was a good deal of enthusiasm for the Obama candidacy and so on. And there was a huge spike in the black turnout, in the turnout of young people, in the turnout of Hispanics and so on. And when I'm trying to say this in a way that is consistent with the ACLU's work as a nonpartisan organization, but the truth be told is that when the Tea Party took over control of a number of state legislatures, then they set about the business of imposing as many impediments to vote as possible in a number of key states, whether that be Ohio, North Carolina is the principal one, Wisconsin, even Florida. We had a half a dozen lawsuits challenging the cutback on early voting, on the number of early voting days, early voting hours. You may recall that, we fought the state to basically a standoff in the courts. But right now we're dealing with is a case before the U.S. Supreme Court out of Ohio. That's actually our case, in which there would be a purging of the voter rolls from somebody who did not vote in 2 consecutive federal elections. So that law resulted in about 40,000 people in the Cleveland area who were scrapped from the voting rolls. We had to go to court. They were reinstated for the last election, but the case went on. It's now before the U.S. Supreme Court. Onerous ID requirements, issues of partisan gerrymandering, that was also before the U.S. Supreme Court out of Wisconsin. That was argued, I think, just last week. Watch out for this Trump voter fraud commission that he has authorized, because that's going to only result in proposals that to more seriously create impediments to the right to vote. And then the last one I want to mention, and I want to talk more in detail with John about this, because if we're going to be fully honest here, well, I think so highly of John. We hired John to represent our coalition before the Florida Supreme Court that got the court, an ideologically divided court that John succeeded in getting to approve unanimously the language of the proposed constitutional amendment to drag Florida kicking and screaming out of the Jim Crow post-Civil War era, in which we have the most significant voter suppression tactic in the country, if not the world, is Florida's system of lifetime felon disfranchisement. 1.6 million people barred from voting for the rest of their lives. Only 4 states have that kind of system: Virginia, Iowa, Kentucky, and Florida, but the numbers in Florida are greater than all of them. So voting rights is a real challenge, and in Florida, for us, it's the number one issue that we are working on. And I'm not sure exactly how this is all going to play out in the cases that are before the Supreme Court and the Pence Chris Kobach commission that Trump has launched. That well, I'm sure that we'll see more voter restrictions.
In reaction to there are a couple things to comment on, and I don't know, Gail, how you want to do questions, if you want to do them at the end or at the end. Okay. So on the issue of voter rights and felons' rights restoration, it's of course interesting that 1.6 million people have been subject to a legal structure where felonies were passed out pretty easily in terms of drug offenses, and they were passed out disproportionately by race. So the failure to restore felons' voting rights substantially hits a generation and individuals who were probably overcharged and were substantially more people of color than otherwise. So it's an important issue for overall fairness. The reapportionment issue is so interesting because it appears there's a chance that the Supreme Court may revisit this. And when Howard and I were talking about it, the logical and intuitive flaw of the current reapportionment process is you can have a state vote over and over again in legislative races, and a majority of the people who voted in that race voted for one party, a particular party. However, the districting in that state resulted in the opposite party winning a substantial majority of the seats. That would make you question the fundamental fairness of the line drawing, and would most logically make you think that the people who continually voted in the majority but continually lost might think their votes were diluted. So that, from a partisan point of view, may be changed and is very important.
This is going to be a crucial thing. It's going to, like a lot of things in our recent history before the U.S. Supreme Court, it's all up to Anthony Kennedy. However he goes on this issue. but it's going to be this is a very, very important issue because there are many places where, just as John said, like there's no connection between democracy and who runs the legislature in that state. The majority of the people vote for one party, but the other party ends up, and I think in Wisconsin, I thought part of the argument was that in 2 elections, more people voted for the same party, but yet the other party strengthened its hand, picked up more seats, and I don't know how that happens. I want to comment a little bit about the felon restoration. I want to go back to that for a second, because as John knows, everybody here needs to know, the legislature proposed and the people voted, I forgot when that occurred, but it now takes 60% to change the Florida Constitution. 60% of the vote. And Florida is a closely divided, ideologically divided state, as you know from looking at some recent presidential elections. So if we're going to make this change, which I think we need to, it's got to be, we have to talk to our neighbors in a way that where this is not about partisan politics. I really think that the way in which the campaign is going to talk about it, the way in which I'm going to talk about it, and I think we are on track to make the ballot. Well, we won't know that, of course, until the end of the year. We still have about 2.5 months to collect several 100,000 signatures to put it on the ballot in November 2018. But the way in which I would like us all to think about it and talk about it, because some combination of myself and John wrote this language, which would rely on John's good judgment quite a bit here, is the way in which former Governor Charlie Crist described this when he changed the rules of executive clemency when he was elected back in 2006, I think, in 2006. I don't think of it as a partisan issue. Who knows what the partisan consequences are? I have to tell you, 1.6 million, nobody really knows. And people should not pretend to know what the partisan outcome is. Nobody really knows. But it's an issue, I think, of ethics and morals. It's a pretty modest proposal. Basically what it says, as John knows, I'm giving the argument that he gave before the Florida Supreme Court, that except if you committed an act of murder or a felony sexual offense, if you made a mistake, committed a crime, that crime was serious enough to be a felony, if you served all the terms and conditions of your sentence, you have the right to have your rights restored. Pretty modest. I think it's more of an ethical, I think, than a legal issue about, you know, what do we really have things like lifetime punishments in the state of Florida? If you serve your time, you deserve to have your rights restored. That's what this is, I think, really going to be about. So if you make the ballot, that's what the campaign, you'll hear a lot about this in the next several months.
There was one other election issue we mentioned upstairs that you might want to talk about, and that was the potential constitutional change in the, there's an existing constitutional provision dealing with primary elections, with which some of you may be familiar. It says that primary elections, if there are only candidates of one party and there will be no general election, then voters of the other party are entitled to vote in that primary, because essentially that is the general election. So what happened after that was proposed 20 years ago by the then Constitutional Commission, the language in the general in opposition was interpreted to include a write-in. So clever people decided if you didn't want cross-party elections, all you had to do was get a write-in. Now, the overall consequence of this is worth mentioning in terms of partisan politics. In some contexts, neither party likes this. Neither very partisan groups would like this, because what it does is allow people of another party to participate in what will be the ultimate election and choice. What that would tend to do is moderate candidates from either direction, which might be a noble purpose based on the current situation.
This is a conundrum. I don't know if Gail did mention this, but this is actually my second career. I have a PhD in philosophy, and I taught philosophy for about 9 years at the University of Minnesota, DePaul University in Indiana. And this is more of a philosophical issue almost, because it is some of the most interesting issues in the law, I think. John was former dean of law school here, but when you have conflicts of rights, and this one is a conflict of rights. So everybody understands. Look, the major voter suppression tactic in Florida is lifetime voter suppression. But the second major one is the one that John is just talking about. You have to think about Florida in politically homogeneous parts of the state. So in Southwest Florida, everybody on the ballot is Republican. The Democrats don't even put up candidates. In Broward County, for example, the Republicans don't try to put up candidates. But here's the best example. In the last election, just this last November, in Duval County in Jacksonville, heavily Republican area, I'm not sure there was a candidate. I don't think there was. There was not a Democratic candidate for state attorney. And the Republican state attorney, rather well known, we don't get into that, well known and very controversial, was running for re-election. So a person, now this is absolutely legal. I mean, this is absurd. And I can't always...
Law is never absurd. We're law students out here.
Yeah, no, you're right. The members of the Florida Supreme Court were absurd when they approved this, that a person who supported Angela Corey, who was running for re-election as the state's attorney in that judicial circuit, who gave Angela Corey money, who supported her, who indicated he had no interest in the job, nevertheless had Angela Corey's campaign manager drive like a bat out of hell to Tallahassee to put in his application as a write-in candidate. He became a write-in candidate. The election then was closed to all Democrats. It was a closed primary. And think about this. Think about this. Maybe about 50% of the people in Duval County, mostly black people, did not have an opportunity to vote for who would be the chief law enforcement officer in Duval County. That tactic is permissible, and John undid that tactic when he was with the Constitutional Revision Commission 20 years ago. Then the politicians figured out that a write-in candidate would sabotage this, and now the Constitutional Revision Commission is thinking about how to undo this. But it's an interesting interplay. I mean, on the one hand, it deprives people the right to vote, but on the other hand, this is what I think John was alluding to, if he and I are members of the Republican Party, we all say, hey, this is our club, we want to choose who our candidates are. You're not a member of our club, get your own candidates. So it's a kind of it's an associational right versus a voting rights issue. It's kind of a conundrum.
I like the fact that you used to teach philosophy. That's great. Perfectly fits.
Right.
Okay, based on philosophy then, which would you rather talk about next, the Constitutional Revision Commission or free speech rights for a few minutes?
Well, it's hard here sitting on the campus not to talk about free speech rights. So with the event that's scheduled for next week, at least we have to mention that, and maybe we'll deal with it more in questions. So why don't we just touch on it? I had expressed some regret publicly when the university president made his initial decision to deny permission to Richard Spencer to speak on campus. And the reason I did that and urged him to reconsider that were really two reasons. First of all, if we have a system in this country, I think, where some unexamined threat of violence or even an anonymous call threatening violence could shut down an event, then there is no free speech. Every time there's a controversial speaker, somebody calls up and says, you know, this is an anonymous threat of violence. You got to go behind that and see whether or not it's real, it's accurate. The other reason is that we've seen this movie before a million times. Controversial speaker is barred by public official. Controversial speaker gets a lawyer, sometimes the ACLU. Controversial speaker's lawyer goes to court, cites the First Amendment. The court is constrained by the First Amendment, rules for the controversial speaker, and awards attorney fees that the university would have to pay the controversial speaker's attorney. You know, it's inevitable. What I said when the president made the initial decision is, what a mistake to make Richard Spencer a First Amendment martyr. Better to expose his hateful rhetoric. So in any event, the thing to do is to do what the Charlottesville police did not do. Use the time to put together a good law enforcement plan that protects the right of the speaker, the right of the counter-demonstrators, and keeps the community and the university community safe with a solid law enforcement plan. I think that's the only option that the Constitution permits, frankly. So I'm waiting to hear some disagreement with that. But
well,
I'm not sure.
we'll have some discussion.
Okay.
Gail directs us to do that at the end. But in looking at the test that the court applies to the First Amendment is, does the event or do the statements potentially incite violence? Right. And is that potentiality actually real?
Good. Thanks for the law professor for bringing us back to the state of what the law is. Very, very good. And that case started in, I think, a 1969 case in which there was a Klan rally outside of Cincinnati, Ohio, if I might remember the facts correctly, in which the Klan person did an interview on TV and was arrested for the incendiary things he said on TV, and the court came down setting what is, I think, what you lawyers call, I have to say, I said I had a PhD in philosophy. I am not now, nor have I ever been a lawyer. So in any event, what lawyers call a bright line, you know, that John just articulated. The likelihood, is there a likelihood, is there a capacity and a likelihood for violence? And the court ruled that his comments in the TV interview did not constitute that. There are some things that are important, that are different than Charlottesville and Gainesville, Florida. Number one, we are not yet, the legislature is trying as hard as it can, but we are not yet an open carry state. So there is no statutory right to march with weapons. And more specifically, and I think more importantly, there is a specific statute barring guns on campus. And so anybody carrying a gun on campus could be and probably should be arrested immediately. But I'd like to hear what John says and you, but I think, yes, there are limits of free speech. Every right can be regulated, and there are limits. And the limits are incitement to violence. So, but I think, I'm not sure that the hateful analysis that Richard Spencer gives about the need to create a white nation somewhere in this country and him espousing what is his Aryan philosophy, I'm not sure constitutes the, I mean, it's odious and offensive and it might move people to anger, but I'm not sure it fits the legal definition of incitement to violence.
What makes that test perhaps more difficult is an increased knowledge or understanding of what circumstances may actually occur. And in the new world where there is access to social media, other issues, other statements, they're in potential defense of the president, because I haven't seen these. There may be a lot of statements that would indicate that violence is likely. So it strikes me that there can be situations where violence is so likely that you would not permanently prohibit, but perhaps reorganize, that maybe that which you can do, which is time, place, and manner, any one of those could present a potential problem of violence. So even the timing could be a problem. If someone said that's so close to Charlottesville and there are people that are coming from Charlottesville and there is greater likelihood, perhaps waiting a period of time may make a difference. Place, where do you locate it? And how do you control the speech? But you don't, the United States has been devoted to not regulating content. And we don't regulate content, so people can say hateful, offensive, ridiculous things. And we will defend that right. But if violence is imminent or likely because of the event, because of the timing, because of the participants, those actual circumstances can change the answer to that question. But it should never be, we don't like what you're going to say. So that discussion is never ending.
Yeah, and I confess weakness in my position because, as an ACLU person, I'm trying to apply traditional principles to new factual circumstances. And John's comment about social media and the organizing effect of social media is really very well taken. But that's the job that I'm in. In the, when was it, the 80s, and more recently here in Florida, we had to apply First Amendment principles to the new communications media of the internet. Was the internet going to be censored by government or not? Everything all the way from the Communications Decency Act adopted by Congress to we represented a high school student who was punished using her own social media and equipment when she went home to write something complaining about a teacher. There's freedom of speech in the new internet world. Anyway, I'm trying to adopt traditional principles protective of freedom of speech and expression, regardless of content, to new factual circumstances. It's not easy.
And one of the interesting things is, yes, the United States has always been very generous, so that there's an interesting circumstance if you compare the United States to various parts of the EU and this. And so there is some irony. In Germany, for example, if your content relates to Nazis, you can't do it. It's illegal. However, if your content would be in the United States profane or obscene and on television, it's not a problem. So Germans think we're strange. And perhaps we think Germans don't give enough latitude to free speech, but that's a cultural issue, and culturally the United States has always been very suspicious of government and wants to encourage the multiplicity of views and diverse and even unpopular views.
See,
so that's the...
For us, that's what John's talking about right now. That's I think the fundamental principle that guides the ACLU. It's that if we're going to end up deciding who gets to speak and who doesn't, the worst option is to give that power to government. Because what's unpopular today is, we're all going to depend upon that freedom of speech, and it's just short-sighted and a mistake to give that power to government. And I regard that as a cure worse than the disease.
So maybe we talk about one more topic briefly and then open it up for questions. You alluded to the CRC, the Constitutional Revision Commission. What would you like to see them do, and what do you think they might do?
Well, and what I pretty much know for certain that some of the things that they are going to do. You know, when John was there 20 years ago, we had divided government. And, you know, divided government maybe gets a bad rap, but divided government forced people with different points of view to come together, sit around the table, and make compromises. We don't live in that world anymore. If you look at I have 15 appointees from the governor, 9 each from the speaker and the president of the Senate. This is, I'm a little worried. I'm very nervous about this because this is the resetting. This could be the resetting of the rules of the game that are going to govern future generations of Floridians. And there are two things that I'm very, very nervous about. One, I think we alluded to, and that is the Article 1, Section 3, no aid to religious institutions. 150 years it's been in the Florida Constitution. No money shall be allocated from the Treasury directly or indirectly to the support of any church or sectarian institution. This is what has blocked not only vouchers for church-run schools, but government monies to sectarian social service agencies. There's been a continuous effort to strip that out of the Constitution, and I know there are some people that are put on the Constitutional Revision Commission solely for the purpose of ensuring that gets stripped out of the Constitution. If the constitutional right of privacy that I think only maybe about a dozen states have an explicit constitutional right of privacy, if that's been used by us primarily to protect the rights of women in Florida, oh my God, I'm nervous about what the Constitutional Revision Commission may do there. Then there are people who have been put on the Constitutional Revision Commission, and I'll end with just this fear, who have been our major opponents on things like LGBT rights, getting rid of the ban on adoptions, so on and so on. And I wouldn't be surprised if at least they would maybe seriously try to consider what Donald Trump just did by executive order, create a religious right to discriminate. I know that may not make sense, but you understand what I mean, that if I own that religion could be a basis for exempting me from obligations to adhere to non-discrimination laws. That the state is essentially, if I don't like a gay couple that walks into my luncheonette and orders a cup of coffee, and the state forces me to serve them because I'm a place of public accommodation, the state is forcing me to violate my religion. Now, some of this is before the U.S. Supreme Court now in another ACLU case that we have out of Colorado. That's the cake maker case that everybody knows about. Anyway, so those are some of there are some wonderful things that they could do, but there are people that are put on there because they have an axe to grind and they've been crusading on one issue or the other. And so the real reason to be fearful is because this could change the rules of the game for generations to come.
The Constitutional Revision Commission has the authority to put anything on the ballot, so it's worth everyone's attention. Well, as a footnote, say 20 years ago, it was that commission in terms of how it was divided by appointments. If you imposed hypothetical partisan division, which is the appointing authority appointed people of that party, it ended up being something like 23 to 24.
Wow.
Or something. So it was incredibly even, and I would want want to represent that was one of the best public service experiences I've ever had, because it within weeks or months I forgot who appointed various people, and they did a very objective job of appointing people who had no axe to grind, where they're trying to do what they thought was the right thing for Florida, and for that reason it was a lot easier to reach a rational consensus, and 8 of the 9 proposals passed. So I think...
Well, we don't live in that universe anymore.
We can be hopeful, but in any case, that sort of thing actually can work. And again, we can be hopeful. So perhaps at this point, Gail, would you like to open it up for questions from the audience on this or any issue?
Who wants to be first? Just come forward to the microphone. Great, Alice.
Any subject is on the table, whether we mentioned it or not.
Thank you both for coming tonight. This is very interesting. I am concerned about the 19th and with Spencer coming. And I'm just wondering, I'm more concerned about the cover of darkness that day. And I'm wondering if legally, if the law enforcement could set a curfew that night.
So the question is, could law enforcement set some kind of curfew on everybody? Well, curfews have been set for safety purposes for all sorts of reasons, including during hurricanes, etc. So it's possible. It's possible.
So I'm the non-lawyer here, so I could be a little bit more cynical. So I could say, you know, what the law is. What the law is whatever any judge says it is. I think so. If the I think John is right. We don't know. It's possible, but if the city or the county or the university granted the permit, but then imposed those kind of time limits, and somebody went to court to challenge those time limits, some judges are going to have to decide. So I mean, I don't know that there's a hard and fast law here. If there's a serious public safety concern, then there may be a legitimate time, place, and manner restriction on free speech activity. It'll be up to a judge.
Good evening. Thank you for being here. I did want to make a point about the Spencer issue that you guys talked about earlier as regards to the First Amendment. I think I do agree in general that it is a bit short-sighted to institute, a ban of sorts, right, and choosing to say that, one party, because we sort of disagree, with his views, that should not be allowed to speak, period. I think that in the long term it protects, the general public, right, and the right to free speech. But having said that, my question regards the last point that you discussed, the CRC, Constitutional Revision Commission. I'm sort of paraphrasing here, but I think I heard you say that I know people who have been put on the CRC for the sole purpose of stripping Article 1, I think Section 3, from the Constitution. I feel like that has deep implications.
I'm sorry.
It has deep implications. I wonder if you can maybe elaborate a little bit on that. Because it was my impression that the CRC was completely independent, right? And it isn't, anyone's sort of a tool, if you will. So if you have, evidence or information just that there are people who've been placed there to fulfill, single missions, if you will, that kind of concerns me. I wonder if you can sort of elaborate on that. Thank you.
Well, I didn't want to give the impression that people were put on there as a tool of, like the governor. The governor put somebody on to tell them what. No, that's not what I meant. What I meant was that they are well-known ideologues of a particular movement, and they were put on there to exercise their ideology. You don't have to believe me, but could then Google the Constitutional Revision Commission and look up, I'll take as an example, a woman named Patricia Levesque, Levesque. She is the executive director of Jeb Bush's foundations. She's basically had one major issue before the legislature for the last, Jeb Bush was elected in what, 1994? No.
Oh, 98.
Yeah, 98. I mean, she is like the leader of the pro-voucher forces. What is preventing Florida from having vouchers to support public dollars to church-run schools? The no aid provision of Article 1, Section 3. So that's why she's there, and that's the crusade that she will carry.
I will only say we weren't asked any questions, and I have no personal knowledge of anybody being asked any particular precondition questions. Some may, and there may be other indications, but I couldn't respond to that. So, yeah.
And again, thank you for both for being here. This is a wonderful program. I'm happy to hear this discussion. I have more of a question about the general jurisprudence around the First Amendment content prescriptions, because obviously we do some content prescription, like child pornography is a content prescription. I mean, we laugh, but if we think about it, what's the reason for that prescription? The harm to the child, the harm to society? Where do we draw the line between incitement to harm and the content of the speech? I mean, that connects more to Nazi ideology broadly, more so than Richard Spencer in particular at UF. But that is, to me, part of the problem in American jurisprudence is where do we draw harm? Because sometimes we say it's harm and it's sort of a disambiguation, and sometimes it's very narrowly specific and we say we have to let them speak because they haven't threatened to shoot somebody over here on the side. So how do we answer that question? Thank you, John.
That's a great question.
Well, first of all, child pornography sits as a unique type of content. It's one of the very few, if only, thing that we use prior restraint on other than national security. We punish people for having it, for making it, or for participating in it, for all those reasons. Because of the harm to the individuals and because of the harm to society. There virtually is nothing else. I'm glad to challenge anybody to give me something else to help me in my classes and tell me what else is treated like that other than national security. Because we don't do prior restraint. Now, you can defame somebody and you'll end up paying for it. You can reveal personal facts. You can violate HIPAA. You can violate other privileges. But to get a court to order someone not to say something, you're only going to get that in minuscule situations. So we in the United States are willing to take the risk. And so other than child pornography and risks to national security, I don't know of other instances where we are that specifically restrained.
So I'm not going to play lawyer sitting next to the former dean of the law school here. So let me give some political reasons why we have the system that we have now. Why we think that I think that free speech is better than trying to come up with figuring out what the restrictions would be and who has the power to impose those restrictions. I mean, I don't want to be flip about the issues of public safety. I mean, that has to dominate. But presuming that the police do their job, which is to make sure that the First Amendment works for everybody, to separate the speaker from the demonstrators, counter demonstrators, and I hope there are counter demonstrators. I hope there are a clear expression that this community has nothing but contempt for the white supremacist and racist views of Richard Spencer, but presuming that that public safety can be protected. I just think politically in this country it is so much better to have people exposed as to what they're thinking than to try to drive it underground. And to have it exposed. Look what we learned, that there is a well-organized white supremacist movement in this country. And for me, one of the things that I thought was really very good, look what it exposed about the mind of our president, who said that there were some fine people on both sides, including those who were marching with their tiki torches, chanting anti-Semitic and racist slogans and so on. It's much better that this be out in public than driven underground, which is what censorship would do.
Hi, thank you both for doing this. First off, on one point about whether or not any of the commissioners were coming in with preconceived ideas, I would just push people towards one article in which Richard Corcoran, who appointed 9 of the members, said in public, in the paper, it was published, that there would be a litmus test. And he was speaking specifically to issues of judicial independence. So I would encourage anyone who's interested in looking that up and kind of trying to understand the integrity of the commission. So that's one thing. I kind of wanted to ask about the no aid provision, though. When you were presenting before the Declaration of Rights Committee last week that was initially talking about this, one of the arguments against the current language seemed to be that it was violative of recent federal case law. I was wondering, and you kind of alluded to it a little bit earlier, if you could talk about this issue of the free exercise clause or religious freedom as a sword to protect one against, how it's being used sort of offensively, because I think that will be an argument against the no aid provision, that it actually already violates law. So maybe you could just talk to that a little bit and maybe how it doesn't violate the federal Constitution.
Is it one of your students?
Yes, Trevor always asks hard questions.
So, I don't know where to begin. So yes, there is this Supreme Court case from last year in Missouri. I forgot the name of the school district. We have since filed briefs in cases subsequent to that indicating that I don't think that Supreme Court decision compels a different outcome in the no aid provision. The argument that you're going to hear more about the no aid provision than the fact that it's now a different outcome is compelled by the U.S. Supreme Court case is the argument that has been used in Florida now for decades, which I want to say, which I think is bogus, but you'll hear it anyway. Namely, it's an origin. It's kind of like the poisonous tree. It's the alleged illicit origins of the no aid provision that it arises out of anti-Catholic bias, and therefore it had discriminatory origins, and therefore it is wrong and should be repealed by the voters. As if a decision by the people of Florida to use public dollars for public schools and tell churches that to raise money from their parishioners to support their programs is anti-Catholic bias. It treats all religions exactly the same way. But that's the argument that I bet you will hear much more than the legalistic argument about whether last year's Supreme Court decision compels a different outcome.
I think it's so much fun to sit with Howard because he claims not to be a lawyer. No, I'm sure he doesn't have a law degree, but Howard's been practicing law for at least 10 years and doing it very, very well. So having said that, what's very interesting about the no aid provision and the religious freedom provision of the United States Constitution cuts both ways. You have an establishment clause which says we don't want the government to establish a religion. And similarly, there's a free exercise clause which says we want people to be able to exercise their religion in the United States. So the argument on the no aid clause is that it restricts the free exercise. And that it isn't quite clear that that's what it does, but that's a very complicated balancing argument because we in the United States want to protect each. We don't want the United States to declare national religion or support it, and we want people to be able to exercise their religion freely. So it ends up being a complex interaction. Now, we can go on much longer about this and too long, so I won't do that. The fact that these amendments originated some way or the other is historically interesting but not legally compelling. So the issue is what do they do now?
Here's the interesting thing. The people who are supportive of using tax dollars to support religion have been just chomping at the bit to strip state constitutional separation of church and state out of our Constitution. But this provision wasn't used to strike down the vouchers. They would have to strike down yet another provision that I think was that part of what you did too. That's the Title IX, the requirement, the education clause that the quality education for every child in Florida is the highest obligation of the state of Florida, and it shall do so by having a uniform system of public education. It was that provision that was used to strike down the voucher program when the Florida Supreme Court, I think in 2006.
See, Howard is practicing law very well. So that was the point is that the provision that the Florida Supreme Court used to strike vouchers was not the religion clause. So hypothetically, even if you change the religion clause, it wouldn't matter if the court adhered to its precedent, which is that that particular voucher system violated the education clause by diverting funds from public education.
Is that creating a dual system of education, maybe?
Yeah.
So in your Florida common law class, we spoke a lot about how the explicit privacy right in the Florida Constitution protects some of the victims' families in cases where they're trying not to get photographs that would otherwise be considered public records released. And we spoke about how it kind of conflicts with the right to the Sunshine Clause, essentially is the right to the freedom of the press to have that kind of access. And I know you worked on some of those cases. I was wondering, Howard, if you guys were ever on the opposite side of any of those cases where public records and maybe photographs that the press wanted to make public. As we were learning that, I just was thinking about the implications and the kind of distinctive
Good.
events.
So full disclosure to Jon Mills, was she one of your con law students? She was also one of our best interns last summer. down in Miami.
So that's where she learned the law so well.
But this is another philosophical issue, I think, in which I don't recall that we've ever been on the other side, but we certainly could be, because there's a tension in constitutional law, I think, between access to public information and privacy. And it is always a tension about, are there some things that are not anybody's business? You were probably involved, or you know about the cases, how much public information is available about people who are public officials. I forgot the outcome, but we had a case that I think we won in federal court about whether or not the home addresses of police officers could be available, things like that. But salaries of university professors, home addresses. I mean, there's a constant tension between whether there's some things that are not anybody's business, but we live in a state that has a very strong sunshine and not sunshine, but public records laws, in which a lot of things are there's public access to.
Well, we are the only state to have a constitutional provision on public access. And as has been pointed out to me by my friends in the media, the privacy clause says not in conflict with public records. So the cases you're talking about, so you will be able to ace the final exam. The courts are finding they're not a public record. And in those cases, let's take the Rawling case in Gainesville, where there was a mass murder and the photos of the crime scenes and the photos of the autopsies were horrific. I don't think anyone necessarily wants to see those. So there's an issue of intrusion upon the close families and an issue of public information. In that case, it's heightened because it's a criminal trial. I would say that the description of the photos provides the public information, and the photos themselves are enormously harmful. And even in that case, Judge Morris, Stan Morris, who's a great judge, balanced that by saying the photos could be observed but not copied. And in one other case, which I think we talked about, the death of the SeaWorld trainer, Dawn Branshaw, there was a video of her death. And one of the things we argued was, if that video were on the open market, it would be illegal in any form. But does the press need access to that video? An expert compared that video to the actual verbal description, which was second by second, of the medical examiner, and there's as much or more information as long as it's accurate. So I guess that argument is there's a balancing test. The goal of public information is as public information available, and if it's possible to balance that with extreme intrusion on individuals, I think we should try. So I don't always come out on the same side as some of my friends in the media on that, but in any case, all you got to do is analyze it and you'll get an A.
One final question.
Yes, thank you for all your work on the restoration of voting rights. And by way of announcement, the local Alachua County Labor Coalition is aggressively working to gather signatures. I regret I didn't bring any of those forms with me this evening. Didn't think about it. But certainly if anyone here gets approached to sign that and get it on the ballot, I would encourage them to do that. A subject that we haven't talked about, and that's the death penalty in Florida. Just would be interested in hearing your views about the state engaging in murder. Thoughts about the fact that we're using untested chemicals on people who are captive, who are not posing a danger any longer to public safety. And then just all the flaws within the Florida system in that we have exonerated 27 individuals from death row in Florida who were wrongfully convicted, more than any other state in the country. When you look at that, 27 individuals who spent varying amounts of time, including I know some up to 18 years on death row for a crime they did not commit, there's something wrong with the system in Florida. Many states in the nation are moving away from the death penalty. Our governor loves to sign death warrants. We just executed someone last week. Less than 24 hours later, he signed another death warrant. So I know the ACLU works on that issue. It's very problematic, I think, and I would be interested in hearing your thoughts on the future of the death penalty in Florida. Thank you.
Wow, let's see, we got another hour. Anyway, this is kind of, for me, this is like voting. I can't, in a way that, I don't know, I moved from 20 years ago, I moved from Michigan to Florida, where I moved from Michigan to the state that takes away the right to vote for more people. I moved from Michigan, where I worked on this issue for many, many years, because Michigan was the first jurisdiction in the entire English-speaking world to abolish the death penalty. They did so when it was a territory. Before it was a state. There's a whole interesting story about how that occurred when the people in the Detroit area in like the 1830s or so realized that they just had a big celebration and picnic and watched the hanging of an innocent person. But I want to say, I don't know what you think about this, John. I tend to be a little naive. Maybe that's why it keeps me going in ACLU work after all these years. I'm optimistic and naive. But I'm looking at this like, I think we're going to see an end to the death penalty in our lifetimes. I think we have narrowed it so much in terms of the mentally ill, juveniles, the last round that we won, where we got the courts to force the legislature to do what we told the legislature they were going to have to do, and that is at least impose the death penalty only when there's a unanimous jury decision, not we were the only one and only state in the country where a simple majority, I mean even Alabama had 10 out of 12, so now it's a unanimous jury requirement. That's not going to end the death penalty, but I think that's going to narrow its application so much that I'm hopeful that eventually, we just won a case in Jacksonville about a month ago that removed somebody from death row. We've been working on this for 50 years, but I do think it's one of these things that, not only the rest of the state, but the rest of the civilized world has moved away from the death penalty. And I think when you even look at public opinion and how public opinion has shifted towards, not when you ask people if they're pro or anti-death penalty, but are you pro-death penalty or would you accept life imprisonment? There's been, I think, a significant diminishing of support for the death penalty. So I'm a little, maybe naively optimistic that we're gonna see a great diminishing of the death penalty in this state and in this country.
I think Howard refers to the essentially chipping away. Also, there's the Innocence Project, basically, that has made even states who sustain the death penalty say there's a moratorium. So the moratoriums provide an opportunity to debate this. And the moratoriums are because I think most people say we don't want to execute innocent people, and now there's serious ambiguity. So it's a position that's in evolution. I wouldn't be surprised if Howard was right.
So I don't want to jeopardize the ACLU. We're going to be we're going to be a 100-year-old organization in 2 years, and we're very proud of our policy and reputation as a nonpartisan organization. So I don't mean to strain that with the following last comment that I'll make, but there might be some relationship between the voting restoration project that you're working on and what happens to the future of the death penalty and the number of death warrants signed by governors.
On that note,
Thank you so much for a wonderful program. Thank you, audience, and I'm sure they'll be here to speak to you if you have any personal questions that you want to ask. Thank you.